This is Pride Month. Yay! And so far, we have been discussing the court cases that have given our lovely LGBTQIA plus siblings basic rights, like the right to get freaky in the privacy of their own homes. And I know, it's a novel idea, right? Being able to get freaky in your own home. But it was a thing. It was a thing. Yeah. So, we are coming up on the right to get married. That was a thing too. Yeah. Now, we just talked about DOMA, the Defense of Marriage Act, and FMA, the Federal Marriage Amendment, their attempt to pass one anyways. Now, let's talk about the first case that overturned DOMA. United States versus Windsor. Now remember, the Defense of Marriage Act, DOMA, enacted in 1996, states that for the purposes of federal law, the words marriage and spouse refer to legal unions between one man and one woman, no same sex. Since that time, some states have authorized same-sex marriages since that time, okay? Now, our story begins with a woman named Edith Windsor, a widow and sole executor of an estate of her late spouse, Thea Clara Spire. Thea passed away in 2008. They were married in Canada in 2007. And their marriage was recognized by the state of New York. However, their marriage was not recognized by the federal government. You see the problem, right? Yeah. State problem? A-okay. Federal law? Not okay. So, because their marriage was not recognized by the federal government, they were imposed, or Edith was imposed, with a $36,000 tax, instead of allowing the estate to qualify for marital exemptions, which would have meant no taxes would have been imposed. So in 2010, Edith was like, this doesn't sit right with my spirit. I think that this is unconstitutional, right? Finally, somebody said it. And she sues, saying, I think this is unconstitutional. Yeah. Now, in 2011, the president and the attorney general was like, what are you going to do? And they choose not to defend DOMA. Side note, guess who was the president in 2011? Just guess. Did somebody say President Barack Obama? Because you'd be correct. Yeah. Now, just because the president and the attorney general was like, we're too busy running a country to worry about laws that are unconstitutional and are currently being sued, does not mean that somebody wasn't trying to defend the unconstitutional act. The bipartisan legal advisory group of the House of Representatives filed a petition to intervene in defense of DOMA and motioned to dismiss the case. Well, the district court denied the motion and later held that DOMA was indeed unconstitutional. The U.S. Court of Appeals for the Second Circuit affirmed. Yeah, they were like, no, I don't understand how this law even got passed. What were y'all smoking? The Supreme Court came through and they ruled that Section 3 of DOMA that defined marriage as being between one man and one woman was unconstitutional. The law was found to violate same-sex couples' rights to equal protection under federal law. They said that it was a deprivation of the liberty of the person protected by the Fifth Amendment, and that the federal statute is invalid for no legitimate purpose overcomes the purpose and effect to disparage and to injure those whom the state, by its marriage laws, sought to protect in personhood and dignity. They were like, no. Paraphrasing. Coincidentally, on the same day of the ruling, the court also issued a separate 5-4 decision in Hollingsworth versus Perry that effectively allowed same-sex marriage in California to resume. Following the decision, the Obama administration began to extend other federal rights, privileges, and benefits to married same-sex couples, like all same-sex couples who are legally married are recognized as such for federal tax purposes, even if the state where they live does not recognize their union. Federal employees in same-sex marriages can apply for health, dental, life, long-term care, and retirement benefits. Legally married same-sex seniors on Medicare are eligible for equal benefits and joint placement in nursing homes. Death benefits are paid to survivors of a same-sex marriage by the Social Security Administration. And the Department of Homeland Security treats same-sex spouses equally for the purposes of obtaining a green card if the spouse is a foreign national. I want you to guess who disagreed with the verdict in United States versus Windsor. Just guess. I heard somebody say Antonin Scalia, and you would be correct. Of course he would dissent. He argued that the court had no power under the Constitution to invalidate the democratically adopted legislation. I don't remember it being democratically adopted. I don't recall that. Never mind the fact that the legislation that was adopted was unconstitutional. Did he forget that part? Yeah. Of course, this is a man who would have said that the 13th Amendment freeing the slaves should not have been passed either. So take it with a grain of salt that this man has any intelligence. I don't know how he passed law school or how he became a judge. Anyways, tomorrow, Obergefell versus Hodges. We finally get to the big one.